want to get ahead, Mr. McMaster. Judge, we're going to have, there's going to be a space like in the one aggravator. The last line is period of significant, then greater drug abuse is on the next line, and it's indented in, and we can't seem to get rid of it. So,
okay.
Judge, number 17, I have the same objection to. As far as, if they want to say the defendant was paranoid or something like that, but saying the specific believed a hit was placed in his life, obtained a gun to protect himself, those are factors to support the argument of the mitigation. And I believe the paranoia has already been covered in, because that was what Dr. Olander is relying upon for, he's under the influence of extreme mental or emotional disturbance. And it's covered in the other one, so I don't believe it needs to be covered again. But if it is, I think number 17 ought to be rewritten as well.
Your Honor, I separated these because they deal with two separate aspects. And one is the response following the death of Trevante Williams in 16. What I would suggest is that...
okay, this is how I changed it. You can tell me if you object.
Join the two. That's what I'd suggest.
Following the loss of his cousin and his girlfriend's miscarriage, the defendant appeared to be distrustful of the motives of others, paranoid, well, you could take out the and. Paranoid, believed that a hit was placed on his life, and obtained a gun to protect himself. Do you have any objection to that?
Judge,
took out increasingly, and I put appeared to be.
Right. I appreciate the court's changes, but ultimately, I mean, this is just an extension of what 15 and 16 were, and it's the court telling the jury what the changes were, what the effects were. And that's the essence of our objection to it. We've already covered the loss of...
because it talks about him obtaining a gun. And it talks about being paranoid.
Well, I agree, but again, I mean, this should not be a laundry list of every little thing they brought out. So that's back to the essence of my objection to all of these in general. But,
Okay. Response from the defense.
Your Honor, it deals with two events in his life which had a profound effect on him. I'm not asking for the word profound. It did have an effect on him.
Okay. Response to my changes.
Which?
Object to my changes.
Oh. As to 17?
Yes.
Taking out what appeared to be done?
I took out increasingly. No and objection. I took out became increasingly. I put in appeared to be.
No objection.
Judge, could the court reread it, please?
Following the loss of his cousin and his girlfriend's miscarriage, the defendant appeared to be distrustful of the motives of others, paranoid.
Okay, hang on one second, please.
And the rest remains the same.
Okay.
So where it says became increasingly, the first became increasingly, put appeared to be. And then take out the second increasingly.
And that ends with believe that a hit was placed in his life and obtained a gun to protect himself. Is it and believe that it?
I actually, when I reread it, I don't think it is an and.
Okay.
I mean, it could be, because it's the third. I mean, I think grammatically it should be, there should be an and.
Okay. Judge, for number 18,
take out the word profoundly.
Right. Our position is that it ought to end after murdered or died.
Which emotionally affected the defendant. I mean, that's the other part of it. That is the mitigation. The event, the effect on the defendant, that's mitigation. There was testimony about that.
I know, but I have a problem with, which I would like it better if it said appeared to be,
Okay.
appeared to emotionally affect.
I'd accept
Appeared,
that.
but you got it several.
Judge, again, my position is the mitigator is the event. The effect it had is to be argued and determined by the jury. The court should not be instructing them on the effect.
Your Honor, this is the same objection to any instruction the court gives. This is no more of
Okay,
In the standard mitigators, they don't talk about the effect. They just lay it out.
They do in the aggravating circumstances. I mean, it can all be viewed by the same.
okay, number 18, I understand the objections. They're the same objections, just in different form. Number 18, several of the defendant's friends and relatives were murdered or died, which appeared to emotionally affect, not affected, affect the defendant. Okay, number 19?
Number 19, Judge, we object to that is the jury, they already have a separate instruction they've been told on the psychotropic medication to start with. There's been no testimony from the doctor who prescribed it, what his diagnosis was, and I don't believe Dr. Olander testified as to what that doctor was finding, what he was doing his prescription for, or any contact she had with him. We've already covered her findings, so this would be in effect what the psychologist at the jail, his findings were and are. He hasn't testified. There's been no evidence as to that.
I'm inclined to stop that the defendant has been diagnosed with and is being treated for mental disorders.
Well, Dr. Zapp testified about the meds. I asked her about it, what they were for, and she, although disagreed with the propriety of it, although she's a psychologist and not a medical doctor, she did acknowledge that they were medications were specifically prescribed for auditory and visual hallucinations. And Dr. Olander testified that in her...
Yeah, but it doesn't say any of that. There's no definition as to what cognitive disorder, NOS, psychotic NOS.
That was the testimony of Dr. Olander. That's what she said. That was the diagnosis for Mr. Brandon. And,
Right.
And all witnesses agree who have testified on it that he is being currently treated with psychotropic medications for auditory and psychotropic medications for auditory.
I agree about the psychotropic medications. You could say the defendant has been diagnosed with and is being treated for mental disorders with psychotropic medications. I don't have an issue with that.
And list them. Risperidone.
My problem is that was based on...
Doesn't say that the meds are specifically for the mental disorders. That's the problem, but I don't see how that'd be a problem, because all the witnesses who testified on it agree that he's got mental disorders, and that he's been specifically treated with psychotropic meds, and these are the specific ones. So it goes hand in hand, and it's unrebutted. Dr. Olander said that...
I'm just saying, I don't think you need to be... If you say they can determine... I propose this. The defendant has been diagnosed with and is being treated for mental disorders with psychotropic medications. If you list all of them, then you're...
Okay, that's... Okay.
Number 20.
Judge, 20 and 21, other than my general objection, I don't have a specific to those two.
Okay.
Number 22, I have an objection to that one. I think, you know, they could argue his cooperation with law enforcement. I think that's kind of a debatable argument, but certainly confessed to all of the offenses which he has been convicted. I disagree with that. I don't think the court ought to put that in. It ought to end, he was cooperative with law enforcement, and then...
Okay, what about the second part of 22? How do you read W-A-I-S-K?
Wait, I got a numbering issue here. Are we talking about the defendant's full-scale IQ, that one?
No.
So,
Number
He
22.
agreed
Well, that's
to
what the
20
court
and
said.
21. He agreed to 20 and 21 other than his general his general objection. How do you read W-A-I-S-K?
that's the Weschler Adult Intelligence Scale.
How do you say it?
Weschler Adult Intelligence Scale.
Weschler?
That C doesn't belong in there. I thought he did, but that's...
If you don't tell me how to say it, I'm going to spell it.
Judge, I would just spell it, because that's the acronym for the...
That's what, I mean, it looks like
W-A-I-S, there's a
Right.
C in there.
The C should not be in.
the C should not be in.
You agree?
No.
Or didn't you say the C? Isn't it?
W-A-I-S 5, or I mean 4.
4. We can take the C out.
I think that scale is...
I think it's correct, though.
Yeah.
Look under the letters.
I don't think it's going to...
Without the C. Well, we'll take the C
Okay.
out.
All right, then number
Appreciate that
20,
concession.
the part he's objected to is the second part, and confessed to all of the offenses of which he has been convicted.
Which is part of the cooperation, and he did do that. Actually, he was arrested. There's no evidence that he did not cooperate with the police. But there was
But did he
evidence.
confess to all of the offenses?
Judge, I don't believe he confessed to the fleeing. I
I
don't
was going
believe
to
he...
say, I was thinking of the fleeing
Right.
too.
And I don't believe he established and confessed to the robbery portion, nor to the taking.
Well, let's take out the two
So-
specific crimes that he confessed, because he did do that. And he talked freely about what happened.
I think this should be cooperative with law enforcement, period, and then we can argue.
He confessed. I mean, that was an issue of the voluntariness of the confession, and that's been placed before the jury.
I didn't ask him about the fleeing.
Right, but he did confess. I mean, he gave a full statement to the police.
Well, you
That's
can't say, but
confession.
he didn't confess to all of the crimes. So
Well,
what do you want him to, and confessed, period?
That's acceptable.
And then 23. Okay, is mitigate supposed to be capitalized in 23?
Probably should not be.
Not anymore.
No,
Not anymore? I just wondered what the standard instruction did.
well, that doesn't, no, we can put a lowercase in, that's
Right.
Okay, then let's go to the second and third pages. I'm assuming that's all standard.
Yes, Your Honor.
Response from the defense.
Where are we now? Oh,
Second and third pages.
the one that starts with if one or more aggravating?
Yes, sir.
That page. No objection.
To the second and third? Or you just read that whole 2 pages and tell me if you have any objections.
No objection to the one that starts if one or more aggravating circumstance.
Okay?
No objection to the next one on the other hand. Starts with on the other hand, and no objection to the verdict form.
Judge, you should have in your packet, we made a correction on the verdict form. Should simply read the last choice should be without possibility of parole, period, correct? I think I swapped it out with yours.
Mine says without possibility of parole, period.
Thank you.
And do we need to do the change on here, or of something to something?
Well, he's doing that. Who's going to do the closing for the state?
Judge, Mr. McMaster will, somehow we lost, we had it done, but the verdict form needs to read by a vote of blank to blank. Is that?
Yeah, that's right.
Momentarily, as here the review.
All right, let me check the mitigating. Good job on the title. With the right font and slant.
I supervised Mr. McMaster for
That
that.
was good.
I did nothing, he did it all. Now go down, make sure we still have, didn't somehow kick, shouldn't for the person. Print.
Okay, looks like those are all the changes that we talked about. And then we're working on the verdict form.
Yes, sure.
And just to confirm, Judge, the state will have initial opening, then the defense goes, and the state does not have rebuttal.
Right. So how long will your, do you anticipate your closing statement to be?
Possible, I found.
Mr. Moore, any objection to this?
With the verdict form?
Yes. They made a change.
No, it's no objection.
Yes, you may. How long does the defense anticipate their closing statement to be? Okay, what I'm going to ask is that you try to limit it to, if you go over an hour, try to limit it to an hour. I think an hour would be appropriate. I'm not going to stop you if you're an hour and 20 minutes, I probably will. Anything else we need to discuss on behalf of the state? Anything else on behalf of the defense?
I would like to take a moment before we launch into closing, and, if I may do that.
Okay, we're going to take about a 10-minute break. We're going to do closings by the state, closing by the defense, probably break for lunch, come back, do the jury instructions, and then go into deliberation. Any questions or concerns at this time?
No,
Okay, let's say be back here at 10:35, and if we'll now